So, me, James Kidd, and Alison Williams talking to you today on the definition of disability. Let's just touch on what are we going to cover today. So I'm going to just talk about these points. Ali's going to talk about identifying disability. I'll then come back and talk about non-visible or invisible disabilities. Ali will talk about types of discrimination, and then we'll talk about confidentiality, and then we'll be done. That makes sense for everybody? I hope so. Let's get cracking. Ali.
Brilliant. Thank you, James. Yeah. So first of all, in terms of disability, when might this come up in the workplace? Well, actually, it can come up before somebody even joins you, and it can come up after somebody's employment has ended in the form of employment tribunal proceedings. Hopefully there won't be any, but occasionally it does happen. So a disability issue can come up at a recruitment stage, for example, because in terms of how you assess somebody for suitability for a role, they need particular adjustments. It can come up at various points during somebody's employment. So a manager might observe that somebody's behaving in a particular way, and there might perhaps be a concern which could relate to a disability. When somebody is off sick, that is sometimes related to a disability, not always, but sometimes it is. Sometimes there are performance issues, and somebody might have a disability which impacts on their performance. That's not always the case. There are some very high performers who have disabilities. Conduct issues, those might arise in relation to a disability, and disabilities might be disclosed during a grievance process. So really, disability is a thread that can run through the employment cycle, and as I say, even before you get into it and also after the employment relationship ends. The key point, I think, is that once an employer knows that someone is disabled, they are under a legal responsibility to make reasonable adjustments and to protect individuals from disability discrimination, which can take a number of forms. So moving on now to the legal definition of disability. Now, the legal definition is not necessarily what you would traditionally associate with what disability means, because it's very specific and it's set out in Section 6 of the Equality Act, which is here on the slide. So a person has a disability if they have a physical or mental impairment, and the impairment has a substantial and long-term adverse effect on a person's ability to carry out normal day-to-day activities. Now, what on earth does all that mean? Well, that's part of the purpose of the session today. We'll try to unpack that for you, because what I see is an awful lot of words that could have an awful lot of meanings, and there have been loads of cases on what is a disability and what do all these words mean. So we'll try to explore some of this with you today. So looking at how we assess whether something amounts to a disability, there are 4 key questions that are really helpful to ask to try to identify whether there's a disability. Now, of course, with it being the law, we don't just limit ourselves to these 4 questions, because these 4 questions lend themselves to additional questions. So the key questions are those on the slide. Does the person have a physical or mental impairment? Does that impairment have an adverse effect on a person's ability to carry out normal day-to-day activities? Is that effect substantial, and is it long-term? Now, I don't know about all of you, but for me, that then lends itself to further questions. Well, what do you mean by physical or mental impairment? What's a normal day-to-day activity? What do you mean by substantial? What do you mean by long-term? And James and I are going to try and unpack that for you now.
I love the word try.
It's early, James. It's early in the day, you know. I'm setting expectations.
Yeah, thanks very much. I know I've come into this very late because Alex is not here, but you know, hey, right. So, however, looking at this, the key questions you need to determine whether somebody is disabled or not. However, the law says if you have certain conditions, you are deemed to be disabled. I'm sure many of you know this already. So as it says on the slide, things like cancer, HIV infection, and multiple sclerosis, blindness, sight impaired, and partially sighted can be therefore a deemed disability, which, as it says on the tin, means the person is treated as disabled, notwithstanding the degree of impact. So you're not into looking at substantial long-term adverse effect, etc., etc. They are disabled in the eyes of the law. However, not all medical conditions are deemed to be a disability in the eyes of the law. There are some exclusions, as you can see on the slide. an obvious one, hay fever. We then being an arsonist, being an exhibitionism. It's hard for me to say. We had a challenge a few years ago from the Church of Body Modification, who tried to say that that was somehow a philosophical or religious belief, and therefore that was protected. But as it stands from a disability perspective, tattoos, body piercings is not a disability. And I think that we can all understand that. It's interesting that whilst we exclude some conditions, the issue can be that just because you're an alcoholic, say, you'd say, well, you're an alcoholic, that means you're not covered under the Act. But if the alcoholism leads to other, say, organ damage or other symptoms, those secondary causes or consequences can be in themselves a disability. So then you would go back into applying the 4 questions to see whether they are disabled or not. Hope that makes sense. Right, Ali.
Yeah, so in terms of unpacking those 4 questions, firstly, what is a physical or mental impairment? Well, it's sort of one of those things that is what it says on the tin. It's just given its ordinary meaning. There's not any special different meaning given to it under the Equality Act. Now, it's something that could be evident, but as we'll go on to discuss, in many cases, an impairment is not necessarily evident, which can be difficult for employers to then identify, is there a disability, what support do they provide, and so on. Now, there's no need to consider the cause of a disability. So the fact that somebody is disabled through their own actions, that they're essentially the author of their own misfortune, if you like, that doesn't mean that they don't have an impairment and they're not potentially, depending on the other aspects of the definition, going to meet the definition of disability. The cause of the impairment is ignored for the purposes of establishing whether somebody is disabled. So the next aspect of this definition is the substantial adverse effect. So substantial adverse effect on someone's ability to carry out normal day-to-day activities. Now, when I hear the word substantial, I think, oh, that's, in the ordinary sense of the meaning, it's something quite big. On a scale of 1 to 10, you might think, oh, that's maybe a 7 or 8. But actually, in terms of the legal definition of disability, substantial means more than minor or trivial. So looking at that scale of 1 to 10, you're probably looking at something that's about 3 or 4. So it's a much lower bar than in the ordinary sense of the meaning. Now, that doesn't mean that it's easy for somebody to show they've got a disability, but in terms of the substantial adverse effect on carrying out day-to-day activities, it does mean more than minor or trivial. Well, how do you identify whether there's a substantial adverse effect? Well, part of that is looking at how does somebody go about doing something and how long does it take them to do it? And that can give you an indication. So, if it's taking someone a really long time to do something, then that might be an indication that there is a substantial adverse effect. The effect of treatment is discounted. So if somebody is taking medication or they're receiving other forms of support, which means that there isn't a substantial adverse effect, that's discounted for the purposes of establishing, well, actually, is there a substantial adverse effect or not? So you've got to ignore that. And then just to note that in terms of progressive conditions, from the moment that an impairment has some effect on someone's ability to carry out normal day-to-day activities, it is considered substantial at that point, even though in the ordinary sense it might not become substantial until some point in the future. So that's just something to bear in mind with a condition that's likely to get worse over time.
Okay, so we've done physical and mental impairment, we've done adverse effect, substantial we've done. Let's do long term. So you'll probably be aware, lasted at least 12 months. So I've had some sort of condition, physical or mental, that's lasted at least 12 months, or it's going to likely to last at least 12 months, or in the horrible scenario, it's likely to last for life, which obviously could be less than 12 months. So that's where the law is looking at it, and we often use that 12-month rule. However, effects can fluctuate. So actually, is that going to to mean that the symptoms are going to be present for the 12 months. The law addresses that. So if, for example, I'm going to use rheumatoid arthritis as an example, it flares up and it's horrible, but then it calms down again, you're going to say, well, that's fluctuating. And the law says, well, actually, if it's going to be likely to reoccur, then that will be covered. So it's looking at it from the point of diagnosis. Is this continuing, or is it going to flare up and down? And that's going to continue to flare up and down, and it will be there. Okay, so normal day-to-day activities, which gets quite interesting. As you can see on the slide, the usual stuff: reading and writing, watching TV, driving. So a mix, using a computer, a mixture of both stuff you do in your personal life at home, and then stuff you do at work, keeping to a timetable, preparing documents, following instructions using a computer. So a real mix. And the law is basically saying that's your threshold. But where we see flashpoints or argument points would be, we get a medical report on somebody, typically from OH rather than from the GP, and they say this person can do these things, but they have difficulty or can't do these things. And one I had recently was, well, the person has memory problems, and this is in the context of menopause, which Ali's going to come on to, but isn't able to do orienteering or bike riding or horse riding or something like that. And you go, well, hang on a minute. Some things are more obvious than others, that's not a normal day-to-day activity. It might be normal for them, but that's not what the law will say is a normal day-to-day activity. So, identifying disability. Ali.
Yeah, so in terms of identifying a disability, it might not immediately be obvious that there is a disability or an issue. But it might become apparent that there is some kind of issue, even if not that it's a disability. So if there are concerns about a particular employee, then something that can be sensible to do is to consider getting some kind of medical report, whether that's from a GP, a consultant, or perhaps from occupational health, to get a better understanding of what the situation is and how it might be appropriate to assist. Now, a medical report might only go so an occupational health report. In particular, it might only go on what the employee says, and to be curious and make their own inquiries and so on. So, it's something that can be helpful, but not necessarily, it will only take you so far. I think that it's best not to make assumptions, and sometimes a medical report will be unclear about whether an employee might be disabled or not. And in any event, as we're discovering from this talk, it is a legal definition rather than a medical one. So medical evidence can be very helpful, but it is ultimately a legal test. Now, if it's unclear whether somebody is disabled, the lowest risk option is to proceed on the basis that the individual is disabled and to look at reasonable adjustments, which we'll be discussing in our next session, and put appropriate protection in place for the individual. But whether an employer decides to do that will really depend, as ever, on what their priority is and what their appetite for risk is. I think for a number of organisations, even if somebody doesn't meet the threshold for disability, they still want to put appropriate support in place. So whilst there's no obligation to make reasonable adjustments, they might wish to consider any adjustments which might help the individual, notwithstanding there's no disability, to thrive in the workplace.
I like that. And we'll be covering reasonable adjustments in the next session. Apologies if anyone saw a pop-up from me, which is our time recording system saying, James, do something with your time recording, I suspect. Okay, like that. So non-visible or invisible disabilities, I think you will all know what I'm going to talk about here. So it's obvious when we've got somebody in a wheelchair. It's less obvious when it's a invisible disability. So as you can see on the slide, concentration problems, gastric bowel. Ali's going to talk about menopause, as I said. The most obvious one are the mental health issues with the autism, social anxiety, all that sort of stuff. And for me, this is about how we deal with this. So less often these days, but certainly in the past, I'll be talking to an employer who will say, well, Fred or Ginger never ticked the box when they were recruited to say they had a disability. How are we to know now when they're making these complaints and they're arguing that they should be treated differently? And there's a whole point there, isn't there, about messaging, and nobody is forced to disclose whether they have a disability or not. We'll come to talk about confidentiality later. But just because something didn't apply then doesn't mean that their position hasn't changed and has evolved since then. So you're in a situation where actually, let's just make it in a situation where it's easy for people to inform, if they want to, their employer, their details, and then that may kick in details about reasonable adjustments, for example. Fundamentally, as I say, no one has to do so. But if you don't do so, then it makes it somewhat harder, perhaps, to manage and level that playing field in the workplace, because you're then as an employee relying on something called imputed knowledge. Well, my employer knew or ought to have known about my particular condition. So that's obviously in a situation where it's with invisible disabilities can be that problem area of, do I disclose it or do I not disclose it? Should it be obvious to the employer that you're in that position? Some of the questions that you can ask of employees, the classic, how are you doing? Not in a Joey from Friends type way, though I would like to emphasize. You seem a bit upset. Is there anything I can do to help? All of those are great. I would say you should be asking all of your teams the same question, so you're not singling out the person that is struggling. Obviously, your duty of care goes to the person that's struggling, but let's be having ongoing discussions. But then if you are with somebody who is disabled or is not obviously disabled, so it might be an invisible disability, kicking into that secondary questions here about what support do you think might help, what would you like to happen now, or having those quality conversations is crucial to be providing the support. And talking of support, menopause is a hot topic, isn't it, Ali? So
Yes, absolutely, James. Yes, there's been a lot more focus on the menopause in the last couple of years. There are increasing numbers of people who are experiencing menopause whilst remaining in the workplace, which is fantastic. But of course, the menopause can have a massive impact on people, and it's appropriate to look at the support that can be put in place. And it's really great, I think, that we're having much more open conversations about this topic. Now, as you would imagine, menopause, whether it amounts to a disability, has been a topic for consideration at a number of employment tribunals. There have been various cases. In some cases, menopause has been found to amount to a disability, and in others it hasn't, because of course the tribunal has gone through the definition that we've been looking at and worked out whether all those boxes that you need to tick have been ticked or not. And one of the cases that the tribunal looked at was Davy and Lothian Buses Limited. And in this case, Ms. Davy was held not to, it was held that her menopause did not amount to a disability. So just to tell the story a little bit, Ms. Davy was suffering from fatigue, constant bleeding, difficulty sleeping, and muscle tension. She was having difficulty remembering the bus routes, and she was a bus driver, so that obviously wasn't ideal. She was struggling with finishing conversations and also with household tasks, so cooking, cleaning, looking after her grandchildren. This occurred from around April 2021. And then in July 2021, she reduced her hours to part-time. And then the effects of the menopause, the difficulty remembering bus routes, the difficulty looking after the grandchildren and so on, were no longer there. She was able to carry out her normal day-to-day activities without a substantial adverse impact. So due to the fact that she was affected substantially for 3 months, she didn't meet that threshold of long term, and as such, the menopause was not deemed to be a disability in her particular case. And I think, as ever with these cases, and it sounds a bit like a cop out, doesn't it? A bit like how long is a piece of string, but each case does turn on its own facts. So, this case is very, very illustrative of that point. So if you don't know whether somebody has a disability or not, it can be helpful to have systems in place to find out. Some organisations have things like a wellbeing passport, or if they don't have their own, you can get them from organisations such as Mind in terms of mental health. There are lots of really useful resources out there. So people filling those in, even if it's not from a disability perspective, but just in terms of ways of working and things that might help them to ultimately contribute to the bottom line. That's something that it can be useful to have. Some organisations ask people whether there are any medical conditions that they would like the employer to be aware of. And as James mentioned, there's no obligation to disclose a medical condition, whether it's a disability or not. Some people choose to, others don't. I think it's helpful to look out for warning signs, and sometimes a warning sign, it doesn't necessarily mean it's a disability, because everyone has life issues, and it might be some kind of life issue that's going on rather than a disability. But noticing actually maybe someone's behaviour has changed gives you the into that conversation and asking those sorts of questions that we had a few slides back, which James was mentioning. It's helpful to make further inquiries with people in a supportive way, refer to occupational health or get medical evidence if appropriate and the employee agrees to that. But as we've mentioned, don't blindly rely on any occupational health advice. The employer sort of needs to apply its own mind to that, and particularly when it comes to reasonable adjustments, occupational health might make suggestions, but the employer needs to think more widely, and I'm sure that will be covered at our reasonable adjustment session next time.
So we're near the end. I'm just going to cover in high level form the types of discrimination that we have in this country, and then just touch on confidentiality. So I'm sure many of you or all of you will know the types of discrimination, but as a reminder, given we're in a webinar focusing on the definition of disability, so the types of discrimination that apply for disability. So direct, A treats B less favorably because of A's disability having been assessed through the four tests, or whether it's a deemed disability. Indirect, there's a policy or a criterion that applies, that has an effect on the disabled person which is disproportionate, can be justified. In that circumstances, direct discrimination obviously can't be justified. A failure to make reasonable adjustments, I need to have longer to be able to do this particular task. Lots of other reasonable adjustments available. We'll be covering those on the next session. Discrimination arising from disability. So A is protected because they're treated differently because of something connected to their disability. So, for example, they've got cancer and they don't get a bonus because they've been taking time off to get treatment for the cancer. So that would be something that is arising from their disability. Harassment in a disability sense. So some idiot is calling somebody names connected to their disability. That would come under the harassment provisions. Or victimization. Either they have done what's called a protected act, which is perhaps raising a grievance connected to their disability, and they are victimized as a result of that, or somebody is supporting an employee who has a disability, and they too are treated less well. So that would count as victimization. So those are the range of claims available in a disability sphere. The main one we see is a failure to make reasonable adjustments. Less often see direct, can see indirect, and arising from. So let's just finish on confidentiality. So what do I mean by this? This is about somebody comes forward, has made the decision to come forward and say, actually, this is where I am. Whether or not they're going to meet the definition of disability is perhaps secondary, as Ali says earlier. We might want to be actually operating on the basis of, I'm going to assume this person is disabled. That can have consequences for your organization, because assuming can do the usual thing, but sometimes it's better to travel in that way. The point about confidentiality here is that this person has come to you and said, I've got these issues. That's not for you to go and tell everybody else about that. You need to be keeping that confidential, obviously, unless, of course, the person can share, or it's obvious and you need to share it. So by obvious, I mean the person has come forward. I'm going to use the trite example of a wheelchair here. It's going to be obvious, isn't it, that they are in a wheelchair. And so therefore there may be some sharing that's required from an adjustment in the workplace. If they do agree that you're going to share information, so what are you going to share as a member of HR, and who with, and how are you going to do it? And has the person clearly agreed to that? And then it would be best practice to have a written record of, you told me this, I'm going to tell these people these things. And so it's clarity. So the person feels supported at the end of the day, that actually what is happening here is they've come to you, they've disclosed the information, and you've said, yes, okay, I will keep this confidential if at all possible, because the exceptional circumstances I've talked about, or I need to tell your manager about this. This is the extent I'm going to inform your manager about this. Some people will be comfortable with sharing everything, some people less so. So you've got to go with an open mind in that respect. Okay, I know that we had quite a few questions coming through. So it's almost past. What I'm going to do is say thank you very much for attending. If you don't want to stay to the Q&A, we've reached the end of the presentation and we'll now pick up some of the Q&A. If you leave now, you'll get the pop-up. Please give feedback. I'm not Alex Lowe, I'm James Kidd. Apologies from Alex for not being able to present. Thank you to Ali, who presented brilliantly. Right, shall we then pick up some Q&A, Ali? Is there any ones that catch your eye?
Yeah, absolutely. So I think the first one, does cancer in remission count as a deemed disability? I think that's an interesting question. I mean, once somebody has cancer, they are deemed to be disabled as a result of that cancer. So that's the position there.
Okay. Question, I'm not going to read out names, but is a formal medical diagnosis required? It's a very good question. It's very helpful if there is, but just because it's been diagnosed is one thing. If it hasn't been diagnosed, doesn't mean that they don't meet the 4 tests. So the short answer is no, but it's very helpful if there is one. Another question, sorry, I'll pick this up quickly. How should one proceed for neurodiverse undiagnosed conditions? That's a very good question and a very apposite question. Carefully, a lot of people think that they are somewhere on the spectrum. We're probably all somewhere on the spectrum, aren't we, in reality? That's not trite. I would travel on the basis of I want to provide support to you as an employee in as far as I can, help describe your symptoms to me, get seen by occupational health or the GP, and then work with what you've got to make a distinction or a decision based on the information you've got. I know that's a bit broad, but this is a situation where we've got waiting lists for 2 to 3 years, haven't we, for neurodiverse conditions. It doesn't seem right, on the one hand, to be saying, well, I'm not going to put in place reasonable adjustments without waiting for that formal diagnosis. On the other hand, as an employer, you will have to be managing, for example, shifts, numbers of things done on a day-to-day basis, should you be making exceptions just because somebody is saying to you, well, I've got these neurodiverse conditions. Getting that balance right, I have to say, is very difficult. Ali.
Yeah, absolutely. So we've had a few questions in regarding specific conditions and whether they count as a disability. And without wishing to give that how long is a piece of string answer, it really does depend on the answers to those questions that we went through. And in some cases, a particular condition might be a disability for one person, but might not be a disability for another person. And that's what we saw with the menopause case we considered. A couple of years back, there were a lot of cases about long COVID, which again can be a disability, but it really depends on the individual in question, how it's impacting them. Is there a substantial adverse effect on their ability to carry out normal day-to-day activities and so on? So without wishing to sound unhelpful, it really does depend on a case-by-case basis. And I'm not trying to duck the question, but it really does depend on the specific circumstances. I mean, in terms of, there's a question about helpful questions that you can put to occupational health besides the different elements of the definition. Often an occupational health provider will send you a form with, here are some questions, which of these would you like us to answer? Actually, you don't have to stick to that. You can put in other questions of your own as well. I think asking questions about the statutory definition is helpful, but what you might want to do is expand on some of those questions. If the questions about the statutory definition are the 4 questions that we outlined, then I think that gets you a certain way there, but it can be helpful to supplement those. And in particular, based on your own observations of the employee in question, there might be certain elements that you want to draw out and draw to occupational health's attention to try to get some really useful information back on the condition and the support that you can provide.
Very good. Just remember that the employer will always be able to see that OH report and the questions that you will have posed. So question, what if an employee doesn't disclose their neurodiversity, but someone else shares this with you? Are you legally required to offer reasonable adjustments even though it hasn't been disclosed? I think that's a very difficult situation. The short answer is no, but you can't close your mind to it. So if somebody says Fred has got neurodiverse issues, I think at that point you need to have a discussion with Fred, which only is at a very high level, lots of open questions at the start, just because Fred may be in denial. And this may be somebody else's opinion, which actually isn't true for Fred. So I think it's right that you or the manager have a conversation with Fred in those circumstances, but are you not going to be kicking into suddenly making reasonable adjustments just on the basis of somebody else's say so? Do you want to pick up that discounted medication one, Ali, or do you want me to do it?
I can't see where it is, so can I throw it to you, James? Sorry.
Outrageous. So question, what do you mean by discounted if they, I'll tell you what, I'll read it out, you can answer it. There you go. What do you mean by discounted if they take medication, as in it doesn't matter if medication removes the substantial impact?
Yeah, okay. So you ignore the effect of the medication, basically. So you proceed as if they weren't taking the medication. So it seems a bit odd in a way, doesn't it? That if somebody's ability to carry out normal day-to-day activities is not affected because medication has helped them to overcome the adverse effects of the condition, you're meant to set aside the impact of that medication and, proceed on the basis that as if they hadn't taken the medication, and that's how the condition affects them.
Okay. I like this one. You can answer this one as well. Is there an obligation to provide reasonable adjustments for short-term conditions, for example, a broken limb?
That's a really good question. I think there's a couple of elements to this. Firstly, with a short-term condition, and probably not a broken limb, but some conditions that might appear to be short-term might actually end up being longer term. And if it's likely that they might last 12 months, then you're into the realm of potentially disability, depending on whether the other elements of the definition are met. So first of all, just a word of warning on that. Secondly, the legal obligation to make reasonable adjustments is only where somebody is disabled. So where you know they're disabled or where you ought to know that they're disabled. Having said that, and depending on the approach of the particular organisation, a number of organisations do like to put support in place for employees, even when they're not disabled, as defined in the Equality Act, just in terms of recruitment and retention, helping people to thrive, and ultimately it does hit the bottom line and achieving the organisation's aims. So even where there's not an obligation, it can be something that's very helpful to do.
That was a very long answer, very legal, very good answer. I would have been punchier, I think, but that was an
Sorry.
no, genuinely excellent answer, I thought. Right, is dyslexia a disability? This is a classic lawyer's answer. It depends. The dyslexia is in itself not a disability, but the effect of the dyslexia may, if we go through the test, amount to a disability. So, sorry, it does depend on that. There's a menopause one, if I read it out, and then we'll probably just take a couple more and then stop. If menopause symptoms last for only a few months but reoccur after a year, does that mean the 12-month criteria means it's a disability or long-term condition? That's
Yeah,
you.
so yes, I think that it will depend on what the likely prognosis is in terms of the effect of the condition at a particular point in time. And actually, I think this goes to the point around fluctuating conditions, that sometimes somebody will be really affected for a period of a few months, and then they'll have a few months where perhaps they're not affected, and then they'll have flare-ups again. So potentially the fact that there's a patch where they're not so affected, that doesn't necessarily mean that there's not a disability and that they're only disabled for the periods where they're experiencing the symptoms in a more severe way, which has an impact on them. So again, a bit of a how long is a piece of string answer, but do be careful with fluctuating conditions. Just because somebody is in a patch where they're not being affected doesn't mean necessarily that they're no longer entitled to equality law protection.
Okay. I think your favorite phrase of this webinar has been piece of string.
Yes, apologies.
Yeah.
But nobody will forget it, will they?
Wasn't a criticism. No need to apologise. Question, penultimate one. What if the reasonable adjustments requested are not reasonable in terms of the role? Very good. We're going to answer that at the next one, the next session. So reasonableness is very good question. Let's just find the last one. In a case where a disability is impacting an employee's ability to perform in their role, despite reasonable adjustments, can an employer safely go down the performance management route? The short answer is yes, but I would put a lot of emphasis on the word safely. So I've got an employee who's not performing. You've got the RH report. You've put in place the reasonable adjustments. You're comfortable. What you've done is support the employee that enable them to actually perform at the level that is right. But notwithstanding that, which is always a good legal phrase, notwithstanding that, they're still not performing. I've got this as a live example. Are we going to put them through a PIP, performance improvement process? Answer, yes, because right now it's not an acceptable output that you're getting from the employee. The question is safely. There's always going to be the danger that the employee is going to see that differently, provided the PIP is there to support them to achieve what you think is the right amount of performance, taking into account the reasonable adjustments, then I think you've got no choice but to go through that. I say you've got no choice. You can always just accept the underperformance or the poor performance, but actually you're doing a disservice to them and their colleagues, aren't they? So I think you've got to do that. Just to remind you that the other sessions coming up, I won't flip back to the first slide on that, but please book into the next two in this session, and to wish you a very happy Wednesday, wherever you may be. And thanks again for joining us. Take care for now.